After killing his father in what investigators called self-defense on Valentine's Day of 2023, Collin was released by Oklahoma authorities and moved in with his mother in Port Charlotte. 7 months into his new life, deputies were once again dispatched to Collin's home after an explosive argument with his mother that turned violent. This body-worn camera video shows Collin in the back of a police vehicle as he talked with his grandmother.
I was saying, I'm not a psychopath. I'm not this murderer. I'm just trying to peacefully leave or peacefully coexist and just figure something out. And she kept telling me to shut up and shut up. And when I wouldn't shut up, she hit me.
No, that's not what happened, Collin. That's not what happened. You never said you wanted to peacefully coexist.
I've been saying that.
The video went on to reveal neither grandma nor mom agreed with Collin's take, but the impasse was driving the teen to beg for another place to live.
Collin did not want to come back home.
Okay.
And I said, you don't have a choice. You have to go back home. And he said, no, I want foster care. And even the corporal was saying, foster care isn't going to be good for you. You don't have issues. You have to work on them.
But the pleas for foster care went unanswered as Collin was released the next day and right back in to his mother's home. That same day, Collin was Baker acted for telling jail workers he wanted to kill his mom. Here in the body camera that day, you can hear deputies explaining to the mom why he's being taken away.
But I struggle with a kid that's being released from jail and saying, if you bring me back there, she's gonna die.
If we don't do something, then,
shame on us.
Yeah, then we're not.
Shame on us that we didn't do our
failed.
job and we failed you. And I'm not failing you, nor am I going to fail your son.
When deputies confronted Collin about those alleged threats to hurt his mother in this video from late 2023, Collin wasn't sure.
I'm in a constant state of fight or flight, and I don't know. If I think she's going to do something, even if she's not, I might act. I'm not going to, like, go crazy or anything, but I'm not sure, honestly.
Okay.
You're not sure if you're gonna hurt?
Only if she tries to hurt me.
Okay.
Less than a year after this incident, Collin called 911 from his grandmother's house in Polk County to report that his mother, Collin Griffith, had fallen on a knife and was bleeding from the neck, a claim that the medical examiner later determined was not possible.
Saying his mother fell on a knife, saying that he had to shoot his father. So now these prosecutors are addressing with the court this prior instance, and the judge is going to have to go through what this jury is going to know. Are they going to know that he killed his father? Are they going to know those circumstances? Are they just going to know there was an incident? Let's go into the hearing that began earlier this morning. So we're rewinding back our tape from the start. Take a look.
If your ruling is against us on the attorney-client privilege, I do have some additional text that might shed some more light. So,
well, all right. My ruling is against you on that, but not due to the nature of the communications. First of all, I want to clarify something. I want to make clear that under the law, it's the intent of the client. When we're talking about the crime fraud exception, it's the intent of the client that's relevant to that determination, and that it's immaterial whether the lawyer knows that the client intends to commit a crime or perpetrate a fraud. And that's from First Union National Bank versus Turney, TURNEY, 824 Southern 2nd. 172. Regardless of that, however, the court finds that the defendant knew or should have known, given, and this is assuming, this is conditional, assuming the state is able to prove that this cell phone was not, was owned by either his mother or a person acting in loco parentis, that the defendant knew or should have known that its contents were accessible by that person. I recognize the argument that you've made that a juvenile has a right to privileged communications with their lawyer. I agree. However, and even you've asked, well, how is he supposed to communicate? And I think I responded he could call his lawyer, and you responded again, well, there could be an eavesdropper. All of those things are true. The court still finds that a juvenile is able to have confidential communications with their attorney under those circumstances. But especially when we're talking about someone who is in this particular relationship with the alleged victim in this case, who knows that she is always watching and observing and is, I don't want to say helicopter parent, but is on top of them, so to speak, that he knew or should have known that the contents of his phone would be accessible to her. So that is conditioned on the state being able to prove at trial, first, that he didn't own the phone outright himself in the account, and that it was either owned by a parent or someone in loco parentis. So I don't know that your additional texts would matter in terms of the basis of my ruling.
Since it's conditioned on the state proving those things, I think if at the time that they're making the effort to prove those things, and I have text to counter that with, we may be sort of relitigating.
What does the state anticipate being able to prove with respect to ownership?
The state anticipates on proving what Your Honor stated here in court.
That the parent owns the phone? Yes? No. I mean...
Well, the state will want to make sure that it's in accordance with the court's ruling, Your Honor. There will be additional things that will be looked into to make sure that everything's
so you
squared
don't
away.
have that proof at this point, is what you're saying?
No, but Detective Peters testified to it at the hearing, Your Honor. I want to make sure that there's any additional...
Was there testimony at the hearing as to ownership of the account, phone, and all that?
Although I don't have the transcript yet, I don't believe he knew that. I believe he said he believed that Kathy had bought him the phone. But as you pointed out, and as I will repeatedly point out, Kathy made things up. And
I understand that.
yeah, and some of the things she bought for Collin and claimed she bought for him came from Collin's trust. So I don't know that they're going to be able to prove who owned the phone.
Did you want to go ahead and proffer that information today?
Sure.
So that everyone can be on notice?
And of course, there don't have all the extra copies of this particular one. This is a text from Catherine to Susan on February 12th, 2024, where Catherine says to Susan, "Hey Mom, I just wanted to let you know that I've been told they're filing the shelter to petition. So I'm waiting just to get that documentation. I guess the hearing is going to be tomorrow and we'll go from there, so let me know because I'm not sure what we're supposed to do. But if this is all being put on by Collin's attorney, who isn't answering your call, and he's also not answering my attorney's calls." So this was offered to show that Collin was in fact, Mr. Ratkin was in fact Collin's lawyer, not somebody else's lawyer. I don't know that that's entirely relevant to your ruling, but I think it's safe to at least have it in the
I was satisfied that you had established there was an attorney-client relationship between Mr. Griffith and Mr. Ratkin. that was not part of my concern.
All right, let me go through these others and see if they address something beyond.
This young man is 17 years old, and his trial is supposed to start next week. And Court TV is going to be covering it. And you're going to hear in this hearing today how it's going to be covered. As with any trial that we bring you, there are restrictions and things that are hashed out ahead of time. So we'll see some of that. But I want to provide you some context for what we just saw. We see the defense team arguing about some messages on a cell phone. What should come in, what should stay out. So apparently these are messages that the defendant exchanged with his mother. She's the victim on this case. And the state is saying that he murdered her. These text messages were regarding the defendant killing his father. So what did the mother know about those circumstances? We know that it never reached the point of criminal charges or trial or anything. It was deemed to be a self-defense incident. But in light of this, we're looking back on that. And what is the jury going to be allowed to hear regarding that instance? All of this is going to come in this morning's pretrial hearing for this kid. So we're going to hit pause. We'll go right back in and hear some more live together here on Court TV.
He attacked me, my dad, and when he did, he tried to kill me with a knife, and then it was in Oklahoma, and he died. So,
Okay.
yeah.
How was that?
I shot him.
Oh my. So there is the young man at the center of a big motions hearing today in Florida. Collin Griffith is accused of murdering his mother. This happened back in September. Now, this was months after he killed his father in self-defense, allegedly self-defense. Kind of makes you wonder now in light of these new charges pertaining to his mom. But his claim with his mom is that she lunged at him, so he says, with a knife during an argument, and that she then fell on that same knife. Police say his story doesn't make sense. Let's go into the courtroom now. His trial is set to start next week, and his attorneys are hashing things out with the judge. What comes in, what stays out? Where we left off, we were looking at some text messages he exchanged with his mother. Makes you wonder, what did she know about his father's killing? Let's go in.
This one is Kathy admitting she went through his text messages, not because she accessed it on his phone, but because she can see them on his MacBook. So I don't know that that resolves the issue at all, because it indicates some subterfuge on her part, not willingly or knowingly allowing her to see otherwise confidential and privileged messages.
I think that's really part and parcel of the condition on my
Right.
holding is that, you know, at its core, a child whose parent or guardian or someone acting in loco parentis, grandparent, whatever, who has some supervisory authority over that child, who has a phone bought and essentially controlled by an adult, that children know these days. Their parents can see what's on their phone or have access and can find ways to access the contents of the phone. So that's really the basis of my ruling. If this phone, and I struggled a little bit with, even if it's not their phone, the parent's phone, even then, because a parent has supervisory authority over a child, they may still even lack an expectation of privacy in the contents of a phone. That seemed a bridge too far given the juvenile's right to attorney-client privilege. And so that was the basis of my ruling. So that seems to suggest that it could either confirm what the basis of my ruling is that he should have known that she had access.
Although this is a communication between her and her own mother, it's not to Collin. I've gone through the messages.
I understand, but in any event, you understand the basis of my ruling?
Yes.
All right. And the state understands the basis of my ruling?
I do, Judge.
As to the actual proof of the crime fraud exception, recognizing that it's, I think, although it's a little bit unclear, that under Florida law, the state or the proponent of the alleged privileged communication and the one claiming crime fraud would have to establish a prima facie showing that the intent was to get information for the purposes of committing crime or fraud. I think the burden then shifts to the opponent of disclosure to present evidence to refute that, and then it becomes sort of a preponderance of the evidence weighing thing. But it's on the limited information before the court, regardless of the eerie nature of the communication, the court determines by the preponderance that the communications were the state has not proved by the preponderance that the communications are excluded because the defendant was seeking advice with the intent to commit a crime. That is not established by the preponderance of the evidence. So the basis of the ruling is that he knew or should have known that the communications would be or could be viewed by another. All right.
And if I,
yes.
Mr. Warner, do you have a copy of the text you mentioned?
I only have one copy. Yes.
Thank you.
And this was from your discovery, so
yeah, thank you. And this is about the mom texting Susan about her reviewing.
Her going through how she was able to see his messages on his MacBook.
I appreciate it. Thank you. All right, Judge.
All right. As to the evidence regarding the Oklahoma killing of Mr. Griffith, Charles Griffith, I want to reiterate again, I think that the case law in Florida is ready for clarification in terms of this issue between Williams rule and inextricably intertwined evidence. And when it's Williams rule, does there always have to be similarity, or is that just for identity? But as best I can determine in this case, I am analyzing it under an inextricably intertwined evidence standard because it appears that one of the motives, the evidence suggests that one of the motives for that the state could prove in this case would be exposure for the crime, the killing in Oklahoma, specifically that he had confessed to murder and allegedly that there was Ring doorbell evidence of it, and that this was on the defendant's, a message sent to the defendant close in time. The court wants to reiterate that as to all of the other purposes for which the state has offered it, while it's clear, and there's really no dispute that Mr. Griffith killed his father, there's absolutely been a dispute as to whether it was the result of justifiable use of deadly force. The state has not proven by clear and convincing evidence that the killing was in Oklahoma, that the killing did not result from a justifiable use of deadly force. So that's why I will not allow it for all of the other purposes the state has offered it. So it's the only relevance that the court finds then is motive for the killing of Kathy. I also recognize the highly prejudicial nature of it, of a child who is on trial for allegedly murdering his mother, for evidence to come out that the defendant allegedly, that the defendant killed his father some years ago. So I don't find that it's relevant what the identity of Mr. Griffith is or the relationship. What is relevant is that the defendant was a suspect, person of interest, whatever they're calling him, in the killing of his father in Oklahoma, but that the fact that the alleged victim in that case was his father is not relevant to that. It doesn't matter who it is. It's the fact that he was a suspect and that now his mother is is threatening to expose him as having confessed to it being a murder. So I will allow the state, through those text messages, to present evidence that the defendant, the alleged victim in this case, threatened to expose the defendant as confessing to murder, but will not allow the state, unless the door is opened, will not allow the state to identify Charles Griffith as the deceased or to establish the nature of the relationship between Mr. Griffith and the deceased in Oklahoma, and also to present evidence that he has yet or has not been charged as of today.
I'm sorry, you will or will not allow evidence that he has not been charged as of today?
I anticipate that that's, I anticipate the state would do that to make sense out of the motive. Mr. Levine, did you have a question?
I did, Your Honor.
So anywhere Mr. Griffith's name appears or is stated in some audio stick, whatever that might be, it needs to be taken out. And any reference to him being Collin Griffith's father.
Did you say, was there something in between the last thing and the first thing where you said the state could talk about the relationship between someone and someone?
Yes, the fact that the deceased in Oklahoma is Collin Griffith's father has no bearing on the issue for which the court has found admission of this evidence relevant. The fact is that he was a suspect in a killing of another human being in Oklahoma, whatever, I can't remember the date now, that he has not been charged with that offense. I'm assuming Ms. Thornhill may have developed that some as to reasons why he hasn't been charged. I don't know. But that he hasn't been charged, and then that the alleged victim in this case threatened to expose him as having confessed that was a murder. But yeah, the name and the relationship are not relevant to that motive.
And maybe the relationship that
and to the extent that they are, the danger for unfair prejudice substantially outweighs the probative value of knowing who it was and what the relationship was.
When you say the relationship, then not the can't mention that it was the deceased was the defendant's dad, correct, or his name or anything.
Family, just the relationship. I mean, how are you wondering whether whether some aspect of the relationship matters? Because if so, let's go ahead and clear that up now. The fact that he has been suspected of murder and not charged, and now has a threat that he's going to be exposed for having confessed to it being a murder, is what's relevant. I fail to see under that limited relevance what the nature of the relationship adds to the mix, whether it's familial, whether it's specifically his father.
So the jury will understand that the defendant was arrested for the crime, but they won't know that the victim or the deceased was his dad or Charles Griffith or anything regarding the name or the relationship, i.e. father-son. Okay.
Unless that door is opened, I don't know if Ms. Thornhill had indicated at the hearing.
This judge has a tough job, doesn't he? So it appears that in these text messages between the defendant and his mother, that she was talking about exposing him for the killing of his father. Now, again, he was initially charged, but those charges were dropped. Investigators deemed it a self-defense incident, and he was never put through the criminal justice system and never went through a trial like he's about to go through next week for allegedly killing his mother. And so now the trial judge has a tough job here, because should the jury know that he killed his father? How should the court handle this? Let's bring in our legal analyst guest. He is the chief trial attorney in the Muskegon County, Michigan District Attorney's Office, Matt Roberts, on the show this morning. Matt, good morning to you. Oh, how might the judge handle this mess?
Well, it sounds like the judge, like you said, has a very tough task here. There's a lot of layers to this, but it sounds like his ruling is essentially that the fact that he had killed his father in some fashion, whether it's self-defense or not, isn't relevant to the fact that it's his father, because the danger there is that the jury would take that to mean, well, if he killed his father, then he probably killed his mother. That's the exact reason you can't use other acts by a defendant against them. You can't just say because they did one bad thing, they did this bad thing. What he is indicating, though, is that if the motive can be established, that the reason he killed his mother is because she was going to expose him for that murder, then it definitely becomes relevant. And then the danger for unfair prejudice is outweighed clearly by the probative value. But tough task, because it's also layered with this argument about the text messages and the prosecution having to establish that there is a basis for them to be able to get to those text messages. So it sounds like he's making a reasoned ruling here. I'm sure the prosecution isn't entirely happy with it, but there's still enough for them to work with as long as they have the evidence.
Yes, yes, great points, Matt. Matt, tell me, as you look at this kid, he's 17 years old, and the allegation is that he murdered his mother, and we know it is a fact that he killed his father. He hasn't been charged with murder at this point for that. We know initially there were some charges, they were dropped. So however that went, it went. But this child allegedly involved with killing both of his parents. What does that make you think? You're a very seasoned prosecutor. You've seen a lot. What does that make you think about Collin Griffith?
Well, it certainly indicates a person with some significant issues, and I'm sure that the Oklahoma authorities at this point are looking with great interest at what's going on in the Florida case, because it could cause them now to go back and re-examine the circumstances here and decide that they can charge this person. Now, it's entirely possible, it's as tragic as it may be, that this is an individual who both of his parents have put him in a situation where he had to use deadly force to defend himself. It stretches the limits of credibility to believe that. It's more likely that there's some trigger with him, some anger issue that is caused by some type of conflict with one or now both of his parents that causes him to act like this. But again, you have to somewhat give him the benefit of the doubt that there might be an explanation for this. It doesn't sound like we're going down the self-defense road in this Florida case, and certainly the circumstances make that more challenging given the evidence in the case that is apparently going to come to light about waiting 2 hours and the crime scene not matching up with any indication that there was any type of struggle. So defense has a tough task here to prove exactly why to make the state prove why he did this, and not necessarily offering an affirmative defense here.
Right. Attorney Matt Roberts, thank you for all of that. Stand by kindly, please. We're going to hit a break. When we return, more of this motions hearing ahead of the trial for 17-year-old homicide defendant Collin Griffith. Thanks for staying with us here on Court TV Live. I'm Julie Grant. So we have a very important hearing happening this morning in Florida for defendant Collin Griffith. So this 17-year-old we know already killed his father. It was deemed to be a self-defense case, but in light of the new allegations that he murdered his mother, well, that may be called into question. We will see. Well, the trial over his mother's killing is happening next week. And right now, the judge has some very important decisions to make because he's deciding ahead of time what evidence comes in, what evidence stays out. And apparently there were text messages between Collin and his mother, Catherine, where she was saying she was going to expose him for the shooting death of his father. Let's go back in.
That case here, I don't know, given my subsequent ruling, whether she intends to do that or to do that as much, but I'm not going to ask her what she intends to do. But if that comes out of the bag, obviously it comes out of the bag.
Now, you mentioned through text. Does that mean that any of the facts of the case or the evidence that I put on at the hearing is admissible, such as body cam footage and/or crime scene photos and/or anything like that?
Mr. Lamine, what is relevant is that he was a suspect, that he hasn't been charged. And I'm talking about in your case in chief. I don't know what Ms. Thornhill is going to do with that. Those things might become relevant. But at the outset of your case in chief, it's the fact that he was, and I don't even remember if they said he was charged.
He wasn't. He was arrested.
Right. So the fact that he was arrested in an incident involving the killing of another human being and that he hasn't been charged is what's relevant from that case. The details of it, unless Ms. Thornhill brings them out in an effort to mitigate the prejudicial nature of that evidence, just isn't relevant.
So the actual exhibit or evidence that would represent that would be largely or wholly the text message that Your Honor is allowing, correct?
I'm assuming that a witness to come to court to say there was an investigation and that he was ultimately charged or arrested after the killing took place.
Judge, this is just off the top of my head, but given the limited nature of your ruling about the state's case in chief, what if, maintaining my objection to any of this coming in, we have stipulation that fits your ruling, but that doesn't waive my objection, rather than having the state have to bring somebody from Oklahoma in just to say that one thing. I understand in rebuttal, if I've opened the door, then they may be able to call one or more Oklahoma witnesses. I don't know if that's an acceptable option.
That's something that could be considered, although I'm anticipating on calling somebody from Oklahoma. So I'm inclined not to agree to that, but I will consider and listen to that. But I'm inclined to call someone from Oklahoma to testify for the limited purpose in accordance with Your Honor's ruling. And just so it's crystal clear, the text message is admissible, correct, Your Honor?
Yes, and I should clarify. I mean, I think you can present evidence that the defendant did not dispute that he killed that person. So I would think you would need a witness for that, or if you agree to a stipulation that would need to be included in there.
Is anything about how the killing happened, such as shot the person, so that there could be some context? Otherwise, it might be the jury will be operating in a vacuum, and it'll be very uncertain. The manner, was this just a complete accident? Was it self-defense? I know we're not going to get into the details, but the state would request that the fact that he shot and killed the individual, that should be admissible.
Well, I don't think any of it should be admissible.
Well, I understand.
Yeah, so I think once we start down that path, then it opens the door, just like I can open the door possibly. I think that opens the door to a whole lot more detail that Your Honor was trying to avoid having the jury hear.
Yeah, in some sense, though, it mitigates because it is a dissimilarity from the present case.
And I haven't thought this through, obviously. I'm being presented with the ruling and...
I mean, it's the fact of a killing that is prejudicial.
We're going to hit pause right here. We'll be right back live with more of this big hearing ahead of trial for this 17-year-old accused of stabbing his mother to death.
I struggle with a kid that's being released from jail and saying, if you bring me back there, she's gonna die.
If we don't do something,
Shame on us.
Yeah, then we're not.
Shame on us that
then
we didn't do our
failed.
job and we failed you. And I'm not failing you.
Oh my gosh, it is eerie seeing that body camera footage. So remember, this is back in 2023, and there was a battery incident between Collin Griffith and his mother. Fast forward to 2024, another incident between Collin Griffith and his mother, Catherine, except this time she didn't make it out alive. This time, she was found dead. Found dead from an apparent stab wound that he said happened when she fell on a knife. That was his story to investigators. Investigators said, yeah, that doesn't make any sense, and now he's charged with his mother's murder. And when they dug deeper, they found text messages where his mother was talking about essentially exposing him for his father's killing. That's right, he shot his father to death. Investigators deemed it a self-defense incident in Oklahoma. They didn't pursue charges against him. But his mother seemed to have known more about that incident. So now the judge has to decide, how much does the jury get to know about it? Does the jury get to know that he killed his own father? I mean, think about it. Well, then they say, oh, well, you kill one parent, you kill the next parent. Can't have that kind of propensity evidence coming in, can you? But if it goes to motive, that mom knew it was a murder allegedly and not a self-defense situation, then he had to take mom out allegedly. Well, motive is an exception to that rule against prior bad acts coming in. So the judge is going to have to sort through this very carefully. Let me bring back in our legal analyst guest this hour. He's the chief trial attorney in the Muskegon County, Michigan District Attorney's Office, Matt Roberts. We saw him put away Shonda Vander Ark with masterful trial skills, and he's on the program this morning watching along. So, Matt, you've said that the court seems to be on the right track. You said it seems that the judge is going to arrive at a reasoned ruling. Tell me how important you think it is for prosecutors to get in this alleged motive here.
In a case like this, the motive is going to be really, really important for prosecutors. It's not always necessary, and it's certainly nothing that is required under the standard jury instructions for a prosecutor to prove motive. But in a case like this, to explain to a jury why a person might want to kill his mother, it's absolutely huge. Now, in a way, it's a little bit of a way to sort of bootstrap that other killing into things, and it sounds like they have a path to do that, but the judge is being very careful to make sure that they can't go too far with it. But certainly as a prosecutor, and that's why I think you see the prosecutor pushing back a little bit, saying, well, can there be some information about how it happened, or what's the limitation on identity? And I think the judge is being very careful to make sure that once it comes out that it's you've blown all of the probative value by the prejudicial value, clearly if that information comes out. So that's why you're seeing the prosecution push back. I think they still have a path that's viable to them, though, with getting the evidence in, as long as they can establish that it's motive. And then it's not even in the realm of bad acts. It's the actual motive for the crime itself.
Mm-hmm. A great point, Matt. Matt, tell me, when you look at this kid, Collin Griffith, and you hear, we just played that body camera footage a couple moments ago, where the officers seemed shaken by him because of what he said, and They said to Catherine, we don't want to fail you here. And you look at him and he seems very calm, cool, collected here, almost kind of detached. Do you think that they're dealing with a dangerous child here?
It's hard not to draw that inference given all the circumstances here, and certainly his actions in apparently killing his mother or allegedly killing his mother raise some question about the validity of his claim that he killed his father in self-defense, and the in-between action there, that domestic situation that we can see the body cam footage of there, only goes to heighten that. The fact that he's calm necessarily in this, I don't think necessarily speaks to what's going on with him. It's just the overall pattern of behavior here. You've got 2 murders bookending another incident where he acts out in domestic violence and apparently stomps on his mother, causing those officers to be concerned about his safety. So it really does speak to what really is going on with this young man, that it's not just a happenstance of it was self-defense the first time and there's some extenuating circumstances the second time, certainly.
Matt, tell us, can we assume that Collin Griffith has had a mental health evaluation as soon as he hit the jail on this case?
I would think so. Obviously, it would depend on the attorney and part of that first communication or the initial communications as to whether or not the person understands the nature of the proceedings. Then you're talking about competency, and I'm sure to a possible insanity defense, but those are really not as common as people might think they are, because there has to be an actual diagnosis of a mental illness to begin with, and then as a result of that mental illness, either the person doesn't understand the proceedings, then again you're talking about competency, or the person just simply cannot conform their behavior to the law, you're talking about insanity. All things I'm sure that the defense has considered in this case, and the fact that we're on the eve of trial and they haven't gone down that road indicates they probably can't even think they can get over that first hurdle of that there is actual mental illness here with him. So that's my theory on that.
Excellent points. As always, Matt Roberts, it's a pleasure having you on this program. Thank you for your time and your expertise this morning. We'll see you soon. And when we come back after this break, we'll take you live to West Virginia for the continuation of the Ponzi scheme murder trial.
This is Court TV Live. I'm Matt Johnson, in today for Ted Rowlands. Thanks for being with us on this busy Wednesday afternoon. Court TV cameras are in several courtrooms across the country today. In West Virginia, the state is expected to arrest its case in chief in the Ponzi scheme murder trial for Natalie Cochran. She's the former pharmacist charged with the murder of her husband, Michael. In Kansas, testimony underway for day 1 of the murder trial for Larry Ingram. He's accused of killing his stepdaughter turned wife. In California, jury selection begins today for the hip-hop star A$AP Rocky, whose legal name is Rakim Mayers. He faces decades behind bars for gun charges and turned down a plea deal just yesterday that would have been 180 days, 6 months behind bars. And in the state of Florida, it's the final pre-trial hearing in the teen stabs mother murder trial. 17-year-old Collin Griffith is accused of stabbing his mom to death less than 1 year after shooting and killing his father in Oklahoma. Griffith will be tried as an adult, and his trial starts on Monday with jury selection. So let's get you back into that courtroom now in Florida, where we've been watching this hearing.
I will allow that, the cause of death to be presented immediately. Was 2 gunshots, is correct? That he was shot twice, so, and that the defendant did not dispute that he shot that person.
Your Honor, if the cause of death is allowed again, and that is the 2 gunshots, my concern is that we're going to get testimony similar to what we had at the hearing, where, you know, there's this argument to be made that the shots weren't immediate, is kind of what the doctor was saying.
I did not say I was going to allow that. That Mr. Griffith was arrested for the killing of another human being who died as a result of Mr. Griffith shooting him twice, once in the head, once in the chest. That's it, unless you develop that further.
I understand.
And I have a question as well. The fact that he was never charged, the sheriff's deputies that testified at the hearing were sort of vague about that. They're like, oh, I don't really know, OSBI took it over. What I don't want to happen is the impression that, you know, as Mr. Levine said, he could be charged at any moment. I think that this jury needs to know that as of today, he has not been charged with that as a crime.
So
who would be able to say that?
Don't want them to say.
Well,
I'm assuming it would be one of those witnesses who testified who would know whether he's been charged or not.
Right, but if my memory of the hearing is correct, and their testimony, it was sort of vague. Oh, I don't really know because
at that time was he charged? Surely they would have known at that time that this came out. These text messages were sent. They would have known at that time whether he had been charged, right? Yeah, we all know he hasn't been charged.
Right, that's what I don't want is the individual from Oklahoma who is going to present evidence that there was a death and it was at the hands of Collin from 2 gunshot wounds. I don't want them to say, I don't know if he's never been charged, or it's not my decision.
They really say that, Mr.
No, I wouldn't. We would not allow them, meaning collectively, Your Honor, myself, and the defense, because the truth has to be in front of the jury. So it's going to be explicitly clear that he wasn't charged.
I think what they were waffling about was whether he was still under investigation today. Wasn't that what they were waffling about?
Once again, I don't have the transcript in front of me, and I could be sort of
how about this?
Misremembering in a way that is inaccurate.
How about the both of you, before this comes in, check in on those witnesses, either now or later, whenever, but before they testify, I would just find it incredible that one of those witnesses who testified would not know at the time these messages were sent.
They know
they're charged or not.
They know he has not been charged.
I would find that incredible and raise my eyebrows during the trial, probably.
Yes, I understand it, but occasionally there are witnesses who try to silo themselves off from decisions that they claim were other people's and claim that because they didn't make the decision, they don't really know.
One of the witnesses was quite straightforward, though, and said we could not disprove self-defense. Didn't one of the witnesses say that?
Yes, but they didn't, and once again, I might be misremembering, but it was the issue of charges being filed, since that's not the sheriff's department's decision.
Right. Well, my memory of the evidence was that was as of today, when OSBI
yes.
took over. That was not my impression at the time, before this killing occurred. It seemed like everything was just in a holding pattern, but they would have known if he had been charged, whether it was OSBI's case or the sheriff's case.
Yes, I would assume so.
So let me know if that's a problem.
And we should get the transcript of the hearing anytime now, and we'll discuss it. I appreciate Mr. Levine saying he believes they know that he has not been charged.
All right. That was all I had to do, right?
Yes.
Okay. We need to have our status. There's several things we need to discuss. I know I saw an email that was sent to you, Mr. Levine, but I was copied on it about what's this statement of facts for it. Has that been clarified for you?
I think so. It's to be read to the jury at the outset to see if anybody has memory of having read about the case, has any knowledge of it.
Is there any objection to that statement?
I would need to, what I said was let's wait and see what the ruling is, and then I'll readdress it. So I can, I'll talk with Mr. Levine about that after. I don't have it in front of me.
It's usually just a couple sentences about where and when it occurred.
County, and yep, and that's what I pretty sure that's all it was, but
All right.
I need to look at it again.
Have you talked with Mr. Levine or any of your colleagues at the Public Defender's Office about how I've typically done jury selection?
Yes. So I understand that you start in the main courtroom with a large number of people. There are some preliminary matters, although I don't know exactly what they are.
I'll tell you what they are. I give the instruction you have to give about researching and talking about the case. I then introduce everyone involved, explain their roles, give them some guidance about how to answer questions in terms of speaking up, not gesturing, those sorts of things. Then I read the indictment.